to take this issue about Mahama Ayariga and the special prosecutor where they feel is necessary for them. But let me start with Mr. Gaga, because you are directly involved in this matter. You want to go to the Supreme Court. This week it played out when a judge, again for the second time, took the Speaker's ruling and said, well, I've heard you, but in this court, I am the boss. I'll determine when he comes. You say you want to go to the Supreme Court on that. Explain. 3 minutes.
Yes, Evans, you see, it's important to put to rest the issue of parliamentary privilege and immunity versus the authority of our courts. I mean, it's a gray area, and the courts themselves have not been very consistent. We've alluded to the Dan Abu Dhabi case. You can also talk about the Republic versus Adamu, Dramani Sakandi. Okay, all these cases have been handled by the court in one way or the other, even in the face of the privileges and immunities that are extended to the members of the legislative arm of government. And issues have been raised, very fundamental ones at that. For instance, a court of law issued orders directed that Honorable Mahama Ayariga be brought before court, even at a time when Honorable Mahama Ayariga hadn't been served with any court summons. Mahama Ayariga was attending Parliament at the time. Now, Mahama Ayariga, out of respect for the court, then decides to attend court and respond to the judge's, if you like, orders or directives. Once he did that, the bailiffs of the court then take advantage of his presence in court and effect the service of the summons on him. Is the service of the summons in those circumstances within the confines of the law? And in light of Honorable Ayariga's immunity and privilege from service when he's returning from court, because on that occasion, remember that he moved from Parliament to the premises of the court to respond to the judge's invitation at a time when the summons had not been served on him. This is so the circumstances of the service can even be challenged. We are saying that, look, for you to make sense out of the issue of parliamentary privilege and immunity, one needs to read Articles 117, 118, and 122. When you have in a purposive manner.
But you cited all that before the judge. She still says.
But we didn't cite them. Remember that we never moved the court. True. Remember that we never moved the court in respect of privilege and immunity. Yeah. The Speaker administratively
did that.
Wrote to the Speaker of the court and certified the issue of Honorable Ayariga's attendance in Parliament on that occasion. What Honorable Ayariga did was to raise the issue of privilege on the floor of Parliament. Okay. Invoking the standing orders in the Constitution.
But interestingly, this week in court, he stood up and said, I would comply.
Yes, because all along, you see, many people have the impression that Honorable Ayariga is trying to run away from justice. Okay. So when he told the court openly that he would make himself available for proceedings to
the 3 minutes are up, though. So that's why we are going to the Supreme Court.
Yes, I mean,
to challenge which aspect of this.
We are not, well, the judge made a ruling, and I wasn't too sure about what occasioned the ruling, because the Speaker's ruling was not a directive to the court per se, it was a ruling in Parliament.
Which the court should have taken cognizance of?
Of course, why not? I mean, you want to draw the attention of the courts
but not
to whatever happens. Yeah, no. He didn't purport to direct the court.
The option to ignore it.
Which did?
Well, if you ignore, you'll be ignoring constitutional provisions and not the ruling of the Speaker per se.
And you have an option.
That is where yes,
to deal with it.
Yes. Okay. So a number of issues have been lined up.
I want to bring it. 5 minutes. 5 minutes. So I want to hear people. I'll come to you. You want to go to that?
I'll give it his time to.
No. Let me hear Kofi, and I'll come to you.
So first, we need to have a certain humble attitude to these developments, because as far as I'm concerned, I think we are forging, our own constitutional systems. In England, it took decades, 100 years, centuries. So we shouldn't be arrogant about the fact that these things are settled. They are not settled. Now, I remember when Professor Dodu was invited to Parliament. I was one of the persons in his team. So I took time to really read about parliamentary privilege. We knew it in passing. And I think as we go along, we would forge something that fits us. But the fundamentals are always important. And I think that's what I want to use my time on. I think our parliament sometimes overplays parliamentary privilege. And we lawyers understand what is called the modern purposive approach, where we interpret our laws purposively to effect a certain progressive end. To that extent, therefore, we should interpret our laws in a way that moves us forward. Parliamentary privilege essentially was carved out of a situation where you have a king. The king is the sovereign. And you have a parliament that represents the people. Okay? After many years of fighting with the king, Parliament came to the point where they said, no, in representing the people, the king must not interfere with us. And the king is the sovereign. You must understand that principle very well. Now, so they have these parliamentary privileges to prevent the king from interfering with their representation of the people. You have, in this situation here in this country, the sovereign is the citizen. So the people that Parliament is representing are the sovereign. You cannot have privileges against the sovereign where the sovereign are the people. These things, I believe, we don't have all the time here, but that's why I started by saying, hold on. Privileges are necessary. But that is why we are having problems when it comes to respecting the courts, for instance. And we are having issues between the powers of Parliament and the powers of the courts. And that's why the judges are saying that, well, the law that I sit upon does not allow me to take your ruling as if it was law. Let us go and let's hear how the supervisors of our realm execute it. But my only caution is that we should all be careful. You may be a parliamentarian tomorrow, not to treat this parliamentary privilege thing as if we had, yes, and it protects, and we have a certain sovereign beside the people. Let's appreciate that when we have a modern system like this, and everybody is subject to the law, the interpretation of some sort of privilege could work a situation where some people are not subject to the law or we are not equal.
That's it.
Yeah, so I'll break mine into two. First will be the process issue, then I'll look at the purpose of the OSP, Special Prosecutor. For me, I think the issue has to do with the content of the certificate that the Speaker issues, because there's no doubt, the Constitution makes it clear that the certificate is final evidence of whether or not the person is available to appear before court. And I don't think that is ambiguous. Now, the question is whether the certificate should be issued on a day-by-day basis or it should be issued with a timetable within it. And I think these are administrative issues that we can. So, for example, from the first day, the Speaker can say, okay, and there are so many MPs, these days it looks like so many MPs have one way or the other been going to the court. So we can develop what we call a content which says that maybe every Monday, and it should be in the certificate issued to the court, and the court is bound to take notice of it. But let's not put it in a way as if the Parliament is directing the court as to how to run its affairs, just as the court cannot direct Parliament to run its internal affairs unless it violates the Constitution. I don't think Parliament too can go into the courtroom and say that, well, before you call the case, call us and let's tell you whether it's available. There should be some predetermined, schedule from the Speaker to the court. So the court will take judicial notice or take notice of it and go by, just as we are, even as an ordinary citizen. When I go to court and I cannot come the following day, I rise and I tell the judge, because I'm attending a funeral or a birthday party, may we take it? And the judges are reasonable people who understand. But when we make it look like it's an order from the Speaker telling the court how to run its affairs, then there is a problem there. Now, my second aspect of the OSP thing. You see, the OSP thing has become a problem not because of Ayariga per se, but because of the institution itself. And I've made these points over and over again. The purpose, why did we even, what mischief were we curing when we brought up this idea of special prosecutor? It was mainly because attorneys generals of the past have not been able to prosecute, or either unwilling or unable to prosecute their own people in government. And that was the beginning. So it started with the CRC, where we said we have to decouple the prosecutorial powers of the AG from the other aspects so that we have an independent person. So the desire to actually have an independent prosecutor was because we want to cure that mischief. Now we have a special prosecutor who, instead of at least in spirit, I mean, driving the institution towards the achievement or the achievement of that aim, is now doing what any attorney general could have done anyway by prosecuting persons of past, and not even doing it in a very, and let's face the facts. Sometimes we can pretend and say that he's just doing his work, but there's more than just doing his work in this particular case.
Well, how do you mean?
I mean,
for the avoidance of that, you have to make it unambiguous.
in your intro, you made it clear that, look, this is a father-son relationship.
No, he said it, the man.
Yeah, the two of them agree that this is a father-son relationship. Now, you have gone on. We are not saying that a father cannot prosecute a son. That is not the point we are making. We are saying that what is the amount involved? I'm not in any way suggesting that the amount should determine how to go, but we need to rank issues. We need to rank it. This is about 30,000 Ghana cedis. That is what we know is on the line. And now we have a special prosecutor who pursued 30,000 Ghana cedis, not just to the extent that he actually went outside.
Is that what is involved? 30,000 Ghana cedis? It's more than that.
36,000.
There's an ambulance one.
Yes,
There's an ambulance one, and then there
is worth 100,000.
Yes.
But it's not because of the cost of the ambulance.
No.
Now the only thing left is how much he has gained from using his political office, which is 30,000. That's the difference. That's what we are looking at. So because of 30,000, the special prosecutor was so determined that he went outside his own jurisdiction and that was embarrassing. Let's face it.
Because it lost that round today. This week.
Yes. So you cannot tell me that this is what we established the special prosecutor to be doing. No. So I think the special prosecutor should take a back seat and review his own conduct and the procedures that he's been using. And sometimes you see, as human beings, we get so passionate about certain issues because of. But if you're a public officer, you need to be dispassionate. You need to avoid ill will or favor, and do your work the way the people intend the work to be done. Yeah. I have a lot of respect for the special trouble. I have a lot of respect for the special
When an episode flies, it will be on your head very soon.
I will be happy to reply such episodes.
Okay. Kweku, you need to use the last 2 minutes to say something.
Well, rather, I've just been told that the pastor has been appearing before the CID since March.
Oh, since March.
So on the previous issues.
So this predates what happened this week. Okay. And one line on Ayariga and
Another time.
Okay. It's been done. Okay, so that's it for a news night tonight. Interesting. We'll see you in the Supreme Court, you said, right?
Yes.
When is it filing? Or
very soon. We've already appealed against the decision of the court not to stay proceedings.
Okay, so that appeal has been filed now.
The Supreme Court.
On the immunity question.
We should put that.
They want to settle it. They want to settle the immunity question. Anyway, thank you very much, and a happy birthday to the former President Rawlings. He is 72 today. My producers tell me, and Mr. Rawlings, Kweku sends his regards as well today. Yes. That's Abdul Malik Kubako, is the editor-in-chief of the New Christian newspaper. Also, Agaga is James Agaga is the ranking on the Defense and Interior Committee. Justice Tremsai is the lawyer and also lecturer. And Kofi Bentil, Senior Vice President with the Money Africa. Enjoy the rest of your weekend. My name is Evans Mensah.